The Honourable Adam Searle.
Thank you, Madam Deputy President. I rise this evening to make a contribution on the issue of the working rights or lack of working rights possessed by the so-called gig economy workers. This term encompasses those who perform work for enterprises or platforms such as Uber, its offshoot UberEats, Lyft, that is Lyft, other ride-sharing platforms and differently configured outfits like AirTasker, Foodora Deliveroo and no doubt many other existing and emerging enterprises. Much has been said and written about the emerging so-called sharing economy. The hype is that this is some hip new kind of work that is caring, worker-focused, that individuals can take up as and when they like, work the hours they choose, and somehow that trifling issues like work health and safety regimes and other basic working conditions like minimum rates of pay do not need to be contemplated, either because they are not cool or would somehow stifle the innovation in the economy represented by the advent of these new kind of business arrangements. If you remove the modern technological trappings, what you have here is no more than the early 21st century version of the Hungry Mile, where unskilled workers would present themselves down on the docks and the gangmasters would choose who from the crowd would work that day and be able to put food on the tables for their families. And it's true that, of course, for some people, arrangements such as those being offered by Uber and other platforms might work to their advantage. However, there are many others who can only obtain part-time or casual work in our economy, who cannot get enough hours pay to meet their needs and the needs of their families, who are forced to seek work on the margins of our economy and to do so outside the protective frameworks provided by the common law or by state and federal employment and industrial laws. I note the decisions that have been made by courts and tribunals in the United Kingdom and in the USA, particularly in New York State, as to whether those who work under these types of arrangements are either employees because they lack the independence that is the hallmark of true independent business people, or would otherwise be entitled to the employment conditions or the working conditions enjoyed by employees. And the fact is that the results of these different litigation processes have been varied. In some, the workers have been found to either be employees or to otherwise be entitled to those employment style rights, and in others they have not been. Madam Deputy President, as a civilised country, I do not believe we can let this uncertainty creep into the law and experiences in our society in New South Wales. As a society, I think we need a framework to ensure that the exploitation we all rightly decried during debate recently on the modern slavery bill in this place is not visited on our sons and daughters as they seek to enter the world of work here in New South Wales, or does not extend to those who are forced to seek work on the margins as I have described. What might that regulation look like? During the passage of the Entertainment Industry Act in this place, I moved an amendment which was successful and became Section 20 of that legislation, which enables the Industrial Relations Commission to make such decisions as are fair and reasonable in any dispute between a performer and those who engage that performer. And I'm told by the union that represents musicians and other performers that it's been reasonably successful. In the point-to-point transport legislation bill debate, I put forward a more sophisticated arrangement which provided for the establishment of award-like minimum employment conditions, including minimum rates of pay for those who work in the point-to-point transport industry. Neither of these proposals were earth-shattering or revolutionary, but I think would be successful or effective in providing those who are not independent businesses, who are not independent contractors, who are not employees, with some civilised and basic, decent conditions of their engagement. They are workers however they are described. They deserve a fair day's pay for a fair day's work, and that is not guaranteed at present by the law of the state and that should change.